All right, we're back for round 2 of the SEC Crypto Task Force Crypto Custody Roundtable with MrConectr. Kind of boring convo, but if you listen to some of the things they're saying, we're getting some of their perspectives out of this. So the first part was this just a few minutes ago. It just ended and they're on a 30-minute break, and it looks like they're coming back now. So I'm playing my synth until they get there. Silver days. Silver's back. D-Cartel is back in the house. They should be starting up any minute. Just playing on my synth for a little bit. Bullish Bird's back. What up? Trying to get my all my synths linked up with MIDI timing. I've got a 404 rolling sampler machine, which can be used, for samples, but it also has a pattern sequencer. If I could get that figured out. I've only had it a few months, so. But this you're hearing now is from this little bitty Roland S1. Let me see if you can see it. No. Actually, hold on. Let's see. No, not that one. Forget which filter's on. I don't know. It's hard to see. It's a little Roland S1. It's like a little handheld synth. I love this thing. Bullish, let me give you a wrench, my man. If I can find my stream. See if I have any other patches. Oh yeah, I was working on this kind of a drum patch off a synthesizer. It's all synth sounds, but I got them sounding like drums. Alright, where are we at? Where is Bullish Bird at? There he is. No, he's the blue Bullish Bird in the house. Blue crew in the house. Blue crew in the house.
Everybody could just take their seats, and if our panelists for the second panel could make their way to the stage, we'll get started in about 1 minute.
1 minute. The countdown is on. Killer reverb. That's without the reverb. Listen to this reverb. I know D Cartel likes that reverb. I can get my synth right. All right, they're about to start back, guys. They're just trying to keep you guys entertained a little bit. Yeah, it is. Cool. And here's some delay on it. Listen to the delay come in here without reverb. You know, not a lot of low end, but you could build on that kick drum off that though. Let's see if I can get a kick drum. That's the 404 kick. I'm sure you do, D.
We're back. Thanks, everyone.
Yeah, we got to hook up, man.
First panel and are joining us now.
That'd be awesome.
Joining us now, or those that are joining us now.
All right, back to the boring stuff.
As you heard, the first panel we discussed custody by broker dealers and the issues under the customer protection rule. The second panel is going to focus on similar issues, but from a different perspective. Custody arrangements for investment advisors and investment companies. Unlike broker-dealers, which traditionally do act as custodians themselves, investment advisors and investment companies are different in that they typically aren't custodians, but instead are required to use third parties to custody clients and funds' assets. While they're separate regulatory issues, in many ways they boil down to similar questions. As you heard in the first panel, broker-dealers holding customer securities through third parties do so typically through banks and broker-dealers. And what do you know, investment advisors and investment funds similarly have to hold their customers or their clients' securities with qualified custodians that are banks or broker-dealers. And unlike broker-dealers that have the option of maintaining physical possession themselves, that's not really been an option for advisors and funds. Some of the policy goals may differ for investment advisors and investment companies than they do for broker-dealers. So the regulatory solutions aren't necessarily the same. Another difference is that the SEC, at least under the prior administration, proposed to amend the rules for advisors to set forth how they custody or safeguard, as that rule proposed it, customer assets, including specifically digital assets. I might be going out on a limb here to say that the current SEC leadership may not move that proposal forward, and there was a lot of commentators that had concerns about that proposal. So hopefully this discussion can help inform anything the SEC does in this space. So without further ado, again, I'm not going to introduce, but please say your name and your affiliation if you start speaking. But I'm excited to get the views of this panel with extensive experience on these issues.
I'll just hang out down
So just
here.
to start, set the stage for the issues we're trying to solve. What are the policy goals? What are the risks when investment advisors and investment companies are holding assets for their customers and funds that these rules are trying to address, and how should they differ for digital assets? Maybe Susan, I can start with you.
Sure. I'm Susan Galt-Brown. I'm a partner at A&O Sherman. So I think the policy goals are to protect assets from destruction, loss, and theft. And I think that's the policy goal no matter what the asset is, whether it's a digital asset or a traditional asset. So in that respect, I feel like the policy goals are the same, but one of the challenges that we have right now is that we have fairly prescriptive custody rules in both the Advisors Act and the Investment Company Act. And it's the specificity of those rules that, I think are causing the most angst, because we just have a different system now with the digital asset ecosystem, and it doesn't fit squarely within the rules that were written for a completely different system.
Larry, can I ask you to add on to that?
Sure. So I think to level set a little bit here, I'm Larry Florio. I'm general counsel of 1KX. 1KX is a crypto-focused fund manager. I think one thing that's important to level set on here is how crypto systems are fundamentally different from traditional finance. In crypto, we've created a technological infrastructure where you don't need intermediaries and you don't need counterparties.
That's right.
There's unique abilities that come with that, and there's unique risks too. So I think fundamentally, I agree with Susan that on the goal of the custody rule. I think that to meet an advisor to meet their fiduciary duty, they have to ensure that their assets aren't being destroyed, lost, or stolen. But also, we should evaluate how to mitigate the risks that are present in the system in which we are operating and investing, and to control for those risks and not unnecessarily add new risks to that system. So with crypto, these are often productive assets. So I agree a little bit with what the earlier panel said, that an asset at rest is often safest, but crypto is not always necessarily intended to be at rest. We have technological solutions like multi-party computation, multi-sig wallets, that allow us to be active on-chain with these assets in a way that I think does mitigate quite a lot those risks that the custody rule is trying to control for.
Adam, on to that.
So the problem that we have is that we're trying to fit a technology designed to be a peer-to-peer payment system into a system for centralized trading. Mm-hmm. And it's not a good match, right? This is why we have these frictions.
At least they're understanding that. That's awesome.
The basic idea of a custodian traditionally was, this is someone who's going to physically hold your assets. They're going to have a vault or something, right? And we're going to make sure that the door is, a sufficient number of inches thick and that it's fireproof for 24 hours, not just for 12 or the like. And
Trust.
That's a really different set of skills than are required to secure crypto. And though I think the idea of a custodian has a lot of merit to it, and there are some, especially when we're an investment advisor, investment company, we probably want to be a little more careful with self-custody in that context. But when you're, or really at that point, the investment advisor would be the custodian if they're self-custodying because they're doing it for someone else. The skill set that's needed is different than what traditional custodians have. And I think that we should be having a regulatory framework that acknowledges that. Now, that doesn't mean that that we shouldn't have any rules about who can be a custodian, but we should be recognizing that your traditional financial institutions may not be the right ones to be doing crypto custody. Actually, may I add
Sure,
one
please.
last? There is one other difficulty, particularly in the investment advisor context, which is the trigger for custody requirements is that it be a security or funds. And the term funds is undefined in this context. We have actually a district court decision in the Electronic Funds Transfers Act context saying that Bitcoin is funds, but doesn't bind us here. I don't think we want investment advisors to be in the position of having to figure out if an asset is a security and therefore whether this rule is triggered. So that does seem kind of important to have some clarity on that legal point.
I would just say, picking up on that, I tend to think that I agree that having an advisor having to decide on an asset-by-asset basis whether a certain asset is within a regulatory scheme or not is very thorny and time-consuming and potentially expensive.
Duh.
So it seems to me that it would be easier and perhaps better to have the regulations follow the entity. So if an advisor has control over assets and is providing investment advice to a client regarding those assets, then you would have the same safekeeping requirements without regard to what those assets are. Similar to the Investment Company Act, which covers just the assets of the investment company.
So I think that will come up again when we talk about the safeguarding rule a bit. But for present purposes, Adam, you started talking about self-custody. Traditionally, there's been limited ability of advisors to self-custody. Self-custody is a weird concept here because it's really custodying for the funds or their clients. Should there be more ability to self-custody for digital assets because they are different, because the kinds of custodians that are traditionally used for traditional financial assets may not make sense in the same way? There's technology that the advisors could use. I guess, what should the SEC do there? Should they expand that to allow it in this context? I see, Chuck, it looks like you've got some things to say on that.
Yeah, Chuck Mooney, University of Pennsylvania, Carey Law School, and New Hampshire Commissioner on Uniform State Laws.
Chuck Mooney.
I think that's an
Chuck.
important question, and we really need to drill down on what is custody and what is self-custody. And it's ironic that in the investment management world, the only self-custody contemplated is custody by someone who's holding for someone else. That's the investment advisor. So it really turns things upside down conceptually. But
I love it.
In thinking about it, we can analogize it to direct holding of a security as a registered owner. But here, often no issuers. And I think we could maybe look at the definition of control in the new Article 12.
He's talking about it like this is like private ownership of your own company's stocks that you never release into the world.
Which I hope the SEC will encourage the adoption
I like this guy.
because it provides the take-free rule for good faith purchasers as well as perfection by control rather than having to file a financing statement to perfect a security interest. But that would be one approach, and it might have to be relaxed somewhat. Another might be to say, well, what is it that a bank custodian does when it has these crypto in an ETF, and sort of work backwards from best practices there. But I think we ought to get to the same place, that it's a functional equivalent of possession of a tangible, which may or may not be accompanied by a property interest.
And what does the SEC have to do with your own private stock in your own company that you never release to the world? They have nothing to do with it because it's yours.
And I would certainly encourage self-custody, and I would like to see, we'll talk more about that, but I would like to see developments of platforms that would make it more feasible and user-friendly and safe.
All right, Chuck. He's the one exception to the bow tie rule.
Maybe I can just
follow on that for a second, and thank you, Chuck, for those remarks.
Thank you, Chuck.
Neil Matra, I'm a partner at Deckert in Washington, D.C.
Here we go.
I think, Zach, what I would say is there's probably a really good case for self-custody now, in the sense at this moment in time. Maybe that's going to be different, as crypto matures in 5 years' time or something like that. But when in the proposal for the safeguarding release, the commission noted that the entire crypto custodial landscape in the U.S. amounted to one OCC-regulated bank, 4 OCC-regulated trusts, approximately 20 state-chartered trust companies and other banking entities, and at least one FCM Futures Commission merchant. So that's not a large number. Those numbers, I think, have changed a little, but they haven't changed vastly. That's one thing I would say. And then we've had, I think, 8 years without any significant guidance around the norms around crypto custody for advisors, I think. So given those two factors, I think that there's probably a good case for saying that at least right now, there is a good case for self-custody coming out of that relative paucity of sort of guidance and that relative paucity of providers. And when it comes to the providers, I mean, we also don't know what the range of assets is that they serve. What is the range of functions that they serve for the assets that they serve? So this is a landscape of uncertainty. And in that landscape of uncertainty, I think self-custody makes sense. I'll say one other thing before I stop.
Good on him, too.
Stop rambling. But I think, in the self-custody context, I think sometimes of a speech that Commissioner Peirce gave in response to an observation by then Chair Gensler comparing crypto to the Wild West. She said, well, in the so-called Wild West, people actually had worked out rules. There was sort of private ordering and there was private contracting. And this is true to some extent of self-custody as well. Many of the better RIAs, I would think, have sort of worked out rules. Now, I'm not saying that examiners would necessarily agree with all of them, and there are former examiners on this panel.
Yeah,
but I'm not saying that those are always necessarily perfect, but I think in this environment and at this time, there is a case for a margin of appreciation for RIAs making good faith efforts to sort of put these rules into practice.
Let's go.
So at this time, and
take it on to the moon.
I think self-custody, I think, is a good option.
Get out, Mom.
I think in some cases, the advisor and the personnel of the advisor are in a better case and are better situated to custody because they know the asset and they know the technology. I found that with many of my clients, that they understand the technology better and the assets are safer with the advisor.
They're talking about
because
us.
They just really understand the technology. And these are advisors, some of them that have come over from the technology side and started advisory firms, or some that have teamed up with technologists and they just truly understand the technology better. So having an option of self-custody, I think, would benefit clients, would benefit investors, and would protect those assets.
It's just like cash.
Yeah.
They're
Justin Browder at Simpson Thatcher. I think
their side.
one of the biggest issues that we face in this with respect to qualified custodians is that in some cases, not all, the requirement forces advisors to choose between complying with technical prescripts of the custody rule and then complying with the fiduciary duty of care. And between those two obligations, if you look back at the commission interpretation from 2019, that obligation always wins out. It's the duty to invest assets according to your client's objectives and to only invest in suitable investments. Right now, the qualified custodian architecture in some cases does not allow for that. So, a couple of examples. Some assets just aren't capable of being reduced to qualified custody. We've dealt with clients where a fund has invested in a project and stands ready to receive crypto assets that have been minted on a new blockchain, and there's no one. They look around and they pull all the QCs that Neil mentioned, and there's no one that's actually available to take hold of those assets.
Because they didn't set the trust line.
Another example is, and I'm sure we'll talk about this later, but trading on crypto exchanges. There are a lot of exchange infrastructures that are not set up through a qualified custodian architecture. And these markets are volatile. I think we can all agree. The markets move very quickly, and advisors, in order to fulfill their fiduciary duty of care, really do need ready and quick access to the markets to trade those assets, to take advantage of potential opportunities, but I would argue even more important, to mitigate against downside market risk. And so when the assets are sitting in the qualified custodian framework in cold storage, it can take 6, 12, I've heard days to move assets out onto an exchange platform, which is
Right.
not a qualified custodian.
Yeah.
So you're really forcing advisors to figure out, do I find a qualified custodian, or do I maximize gains for my client in the way that they've contractually mandated that I do?
Mic drop.
Go ahead, Ryan.
Yeah, I was just going to mention one more thing. So Ryan Loeb, our Wisdom Tree, we issue exchange-traded products that invest in digital assets. We also issue digital assets and tokenized real-world assets that have a registered investment advisor as well. I do think it boils down to, the core of the Advisors Act focuses on the who in terms of needing a qualified custodian, a bank, broker-dealer, as opposed to, I think this framework really needs to focus on, which I think what a lot of us are saying is the how. What is the access control? What are the security measures that the how is implemented, and who is doing that, I think, is somewhat less important. So if the advisor can do that via self-custody, how is it doing it? Can it ultimately meet those policy goals that Susan started off with in terms of securing assets, in terms of ensuring that those aren't compromised, they can't be stolen, or there's no theft? I think it becomes less focused on self-custody versus entity and sort of how. What are those controls?
And there already is a model for self-custody in the custody rule, albeit that if an advisor self-custodies, it has to be a qualified custodian or if it's a related person. But I think the commission could look to some of the structures and safeguards that are there, the internal control report, surprise exam, add another surprise exam, give investors disclosure, given the disclosure-based regime. And I think that would go a long way to satisfying some of the concerns. But there is this structure there that I think the commission could look to that has existed and is the gold standard, as someone in an earlier panel mentioned.
And just to follow on that and Ryan's point, the how, are there views in terms of, regulators are going to regulate? It sounds like there's a lot of agreement that advisors should be able to self-custody. But how? Like, under what conditions, under what standards, what are the safeguards to make sure that even if they are self-custodying, is it those surprise exams? Is there more, are there features of this technology that make it, more adapt or more amenable to self-custody? I don't know, Chuck, can I start with you? If you've got views on the how?
Well, this is far beyond my expertise, but I can point you to the papers on Neil's bio and on Susan's bio, where they explore how an advisor in self-custody could nonetheless could be provided, I'll say, the same kinds of protections that we contemplate would be provided by a qualified custodian. And I think that's,
decent
as Neil suggests, the future is to find ways that a person can be in direct contact with their own assets, but nevertheless, without putting a custodian in the chain of title, we can have those same protections that are contemplated by the investment management ecosystem.
Get it, Chuck.
And I'd say, too, one of the reasons at Wisdom Tree we've gravitated toward blockchain is really the transparency that it provides, which I think have some potential unique benefits here in terms of being able to track, the assets that are in a particular wallet can be independently verified actually by third parties without, going into necessarily the advisor's office, so long as it understands those wallet addresses. So there's a level of transparency, also immutability with those blockchains that really doesn't historically exist in the traditional financial landscape, that I think that technology, potentially lends itself to sort of rethinking how these assets are viewed in the custody.
Now you're getting it. It's better.
So that, coming on to that point about it being visible on the blockchain, this came up a bit on the prior panel, is that a solution? That, advisor can tell its clients or tell regulators or tell its auditors, here's the wallet address, and they can go and look and see that they're there at all times. Susan, is that sort of eliminate the need for a qualified custodian? Because, you can have the auditors and regulators just watching the wallet and getting alerts if things disappear?
Depends on the person. Give us whatever we want.
It depends.
Exactly.
And that's why I think ultimately we need a principles-based solution, because different advisors are going to have different business models
Right.
and different levels of knowledge about how to deal with digital assets. So for some advisors, it will be completely reasonable for them to self-custody and to say, we have a comprehensive record-keeping system that's implicit in the blockchain. Other advisors, it's not going to be as clear, and so
And there's saying self-custody for the actual advisors, not us self-custody on this segment.
it might be that for some assets and for some advisors, you want to have a qualified custodian. And then we have to think about what do we mean by a qualified custodian? Because again, just because a bank is a bank doesn't mean that that bank has expertise in custodying digital assets.
What?
So I think we have to think, like, what is it about these entities that makes them qualified custodians? So there might be things like, is the entity regulated by a regulator?
Ripple.
Does the entity have
Medico.
to maintain policies and procedures and controls? Does it have a capital requirement? Is there a resolution authority? And is there an audit that's required by a third party, not necessarily an accountant, but maybe somebody who's an expert in auditing blockchain technology? And then at the end of the day, you have the blockchain itself, which is itself a record-keeping system, and it's immutable, and you can trace it if you know what you're doing. But so I think
They're still talking about
there's a lot of
jurisdiction.
things to think about that are in the mix. And it might be that
It's
for
all
some
about who gets to
advisors,
rule over what.
one-person advisor who's just entering the space may not feel that they can, look at the blockchain and be able to analyze, are the assets where they're supposed to be? And for them, a qualified custodian might be the answer. But for a much more,
Right.
an advisor that's established an in-house capability, self-custody might be reasonable as well.
Yeah, if he's got insurance.
Justin, do you have a view
Yes.
on the extent to which that kind of transparency level could solve this question?
So
they're gonna fist fight.
if you kind of trace back the history of the Advisors Act rule back to 1962, you kind of can pick up three themes, right? So there's the requirement to safekeep assets securely. There's a requirement to disclose to your clients where those assets are, and then there's always an independent verification aspect to the rule. I think the publication of an address helps satisfy two of the three, but I agree with Susan that there's likely a requirement to impose some sort of principles-based standards around making sure that the assets are actually kept safe, whether that's through a qualified custodian or on a self-custody basis. And you can kind of frame that requirement around a bunch of different principles, because I think that whatever rule gets adopted or amended in this case needs to be technology neutral. We've talked a lot about that today. What's current today will be obsolete in a week in this space. But you could think about imposing some general standards around policies and procedures, record keeping, things. The commission could look in its current toolbox under the Advisors Act to pull out certain control frameworks to ensure safekeeping as a sort of to hit that third of the three policy objectives that I mentioned.
Just picking up on something you said about technology neutral, I agree with you, but I also think that it's important to not miss that there is this technology that can address the concerns that the commission had in 1962 or whenever they originally passed it, and has continued to be a concern that there's transparency and that the assets can be verified and looked at by the client if the address is given. So I think technology neutral, but also keeping in mind when they're thinking about a principles-based approach or a relief to consider that the technology does what existing.
In other words, don't eliminate third-party jobs or third-party
So I
custodians.
Plus one to Justin, but
Never mind the peer-to-peer aspect of this stuff.
the checking whether assets are on chain, that's a great way of making sure that the assets are there now, but it doesn't tell you anything about whether they're secure in an hour or in a day, right? So you need, I think you want the transparency of being able to check on chain, which then means not having custody through omnibus wallets, and then having in addition some set of regulations that are going to ensure that that those assets will remain secure. So, auditing, making sure that there's certain procedures for keeping track of books and records, for securing private keys, so forth.
So I've heard some suggest that third-party custody through a qualified custodian or otherwise may be less secure than self-custody on the basis that that means somebody else is holding the private keys. You don't know what's going to happen with that. Is that a legitimate concern? And if so, should the SEC go in the opposite direction and actually mandate self-custody rather than say that you need to that advisors and firms need to use qualified custodians? Ryan, I saw you.
They won't do that.
I was going to hop in. Well, I think it goes back to that point around the experience, which we heard a little bit on the last panel. I think that with the traditional safekeeping system, you could say, okay, a bank can really perform this function. I think, though, that the technology and understanding, the operational procedural safeguards that are really necessary to, ensure that the crypto asset is safe or the tokenized asset is safe is different. And so I think that requires, a level of experience that a traditional custodian, may not have. Now, but I wouldn't swing it over to say, okay, that's complicated, but there are certainly parties, or ourselves included, that can do that well. But I wouldn't then switch it to self-custody. I'd say I think choice is important, but going back to those core safeguards and the principles of custody to give choice. And to me, part of that in the digital asset experience is choice. That's why I think a lot of investors have gravitated generally toward digital assets, is because they have a choice in how they want to hold them, for instance, or who they can use. And I think that sort of permeating through generally, this regulated infrastructure is incredibly important, though does need to respect that choice and that there are differences here.
Chuck, please.
Yeah, I would agree with that completely, even though I have a, sort of a bias towards self-custody and at least exploring that. What I would suggest, however, the SEC might do is mandate that if a custodian, where used, is going to maintain a securities account type arrangement with its investors, that it have to opt into UCC Article 8, which wouldn't automatically apply as it does for banks and broker-dealers for securities, but you have to opt in when it's not an Article 8 security, and I would strongly encourage that. Me
either, lunatic.
So maybe, Zach, I can add one thing to that. I think completely in agreement with everything I've heard so far, and especially the fact that this doesn't yield to sort of this doesn't yield absolute rules. There are going to be cases where self-custody makes sense. There are going to be cases where a third-party custodian makes sense, and that differs, obviously, from asset to asset. But I think it also differs from firm to firm. And I think one thing, of course, which Ryan has sort of picked up on, others have also mentioned, is the sophistication of the firm. But the other thing that is also relevant, I think, is the firm's business model, or rather where it sits on the spectrum of private funds, or in the sense that if you're dealing with any kind of fund, really, not just private ones, but if you're dealing with, say, a trading shop, the expectations around the assets and how the assets are going to be used are going to be vastly different from, let's say, a traditional venture capital firm where you might be holding the tokens for a period of years in certain cases. So again,
she's in the back,
stressing the fact that there aren't absolutes, but I think one thing, and I think this is going to be a prime area for examiners as I keep coming back to this point. But when they look at it, when examiners examine these practices, obviously looking at the nature of the asset is going to be very important, but looking at the nature of the firm's business is, I think, going to be equally important.
Just want to pick up on one point that Ryan made on choice. Just going back to the Advisors Act fiduciary standards, they are grounded on notice and informed consent. So one of the things that would be worthwhile in exploring any future amendment or rule is figuring out whether it might be possible to get buy-in from advisory clients about exactly how they expect their assets to be held. That would, in my mind, be consistent with Advisors Act orthodoxy, and especially for sophisticated clients like a 3C7 fund or otherwise, it doesn't strike me as totally unreasonable to offer clients a menu of options around custody and let those clients choose what they believe is most appropriate for them.
There you go. Let us choose.
So I want to kind of go back to first principles with something Susan said about that the real goal here is keeping customer assets safe, right? And what are the kinds of risks that come up in this context? Well, there's a hacking risk. That's just kind of the outside theft risk. There's a, what we might call defalcation or misappropriation risk. That's the inside theft risk. And unfortunately, we've seen a lot of that, at least in 2022. We had that with FTX. We had that with Celsius. Right? This is not an unknown risk, even though it seems to be particularly sharp in the context of companies where there's a large personality at the helm. But then there's a third risk that we haven't talked about, because all the questions about sort of, who has the technical know-how, that's really mainly going to the hacking risk. And making sure we have enough, that we have good policies and procedures and examinations, that's more on the defalcation risk. The third risk, though, is an insolvency risk. And it's not obvious to me that the hacking risk or the defalcation risk is any different whether you're talking about having a self-custody solution or a third-party custody solution. It exists in both. But the solvency risk might be different because the solvency risk deals with the other operations of either the investment advisor or if it's a third-party custodian. And generically, it's hard to say where there's more problems on the insolvency risk side. But I think ideally you want to find you want to have the custody done by the party that has the least insolvency risk. And that part of this, there's some solutions with the insolvency risk. The UCC Article 8, as Chuck raised, helps clarify that at least for the crypto that's left around, who has an ownership interest in it. Right? It doesn't mean that there's going to actually be any crypto in the cupboard when you look, but
no, not making the moon party. No,
makes clear whose it is if it's there.
Not this time.
But if we really want to start addressing the solvency risk, that then starts taking us back to questions like, why do we have a qualified custodian requirement that pretty much limits us to, more or less to banks? And that's because we have a prudential regime for banks that makes sure that they usually don't end up insolvent, and if they do, we have a pretty good way of resolving them. So I think that's something that we need to be thinking about is not for the inside versus outside, where can we best address insolvency?
Yeah, we need some representation, don't we, Evan?
So is there a bit of a middle ground between self-custody and qualified custodian where an advisor would arrange with a qualified custodian for multi-signature wallets, multi-party compute, such that the advisor has the asset themselves, but they can't really move the asset without the third-party qualified custodian or other third-party co-signing on the transaction? So you kind of, is that a way to get the best of both worlds? Does that solve anything? Would that be sufficient? Ryan, if you've got views on that.
Yeah, I mean, I certainly think that that multi-party computation can be a way to solve that single-party risk where you've essentially sharded the key the advisor has access to. I don't think the other two, or however many shards, need to necessarily be sitting with a qualified custodian. But so long as it's a custodial-like entity that has these first principle safeguards associated with it, so I don't think it needs to necessarily be a bank or a broker-dealer, which I think we should think about in the rules. Again, that goes to sort of the experience within the field of that entity.
The best custodian is an AMM.
But I do think that solves some of the control problem. If the advisor is the only one that can essentially trigger the movement of the asset, then that does, while the other portions are sitting somewhere else. And again, that advisor would need also operational safeguards to ensure, who is pushing the button, if you will. But I do think that's one way to potentially solve it, yes.
And solves the point raised earlier about taking a day or two or three to get things out of self-custody.
Yeah. No, most definitely. I mean, that is the goal of, I think, blockchain-based assets is trying to move to essentially, not only atomic settlement, but at least near instant settlement. I think of the securities world where we just moved to T+1, which is fantastic. We have that in the ETFs, and it's really, really incredible. But, we are able to issue assets that are, tokenized real-world assets that can, non-securities that settle literally immediately. And
Uh-oh. What happened?
I certainly think it's a good thing. I mean, MPC, sharding, whatever control splitting mechanism you have, I think
Sharding.
is a good thing, and perhaps better to have than not. But that said, I mean, my experience with custodians, and perhaps the experience of many with custodians, is that they're pretty inert and they don't like to be asked to decide anything, really. And the indemnities in those agreements kind of typically reflect that. We're not responsible for basically anything. And so
Sounds like a trustee to me.
yeah, well, oh gosh, don't get me started on those guys.
The words out of my mouth.
But so
Get 'em,
given
Chuck.
that, I mean, I think, again, good to have, but let's be realistic about how far this will get us in terms of true defalcation that involves, bad intent, elaborate plans, schemes, and other things. So,
Well,
that would
yeah,
be my
going to
qualification.
Larry's point,
Get him, Chuck.
if they hold a shard, what do you need to give them to get them to actually sign with that shard? And does that sort of undermine the whole point? If it's too easy, then what good are they? If it's
I held
too
a shard
hard, then
one time.
you don't want to use them.
Yeah, I plus one on what Neil said. I think custodians, generally speaking, don't want to be responsible for any decision-making. They want to be told what to do and then do it. I think the other issue with having,
Yeah, they will.
I'm not anti-custodian. I actually just think that it depends, again, on the advisor and it depends on the systems. But to the extent you do share either a
I'm not anti-custodian. I'm anti-free markets.
key or a shard or any aspect of control with another third party, you're adding an element of risk with respect to these keys. So it's as though, I make a copy of my house key and I give it to 5 people, and that's going to ensure that I don't get locked out of my house. But now 5 people can potentially walk into my house. And so I think it's the same when you start adding on service providers to an advisor and you're asking them to hold part of an asset.
Please.
Could I just return briefly to Adam's point on the credit risk and insolvency risk, which I think is real. Essentially, it's been reduced to near zero for legacy securities for a variety of reasons, including SEC regulations, 15c33, SIPA, and the like. And I'm not aware of any failed bank where there was a shortfall of securities, even though they have something not like a fancy customer protection rule. They have a rule along the lines of, keep your customers' stuff. But maybe that's a little more elaborate than the rule. On the other hand, if we've got intermediaries with financial assets who are not banks or broker-dealers,
Chuck tells it like it is. Get him, Chuck.
then we could have a wide variety of the sort of supervisory and prudential requirements that are there, and the risk is real, and that's something that Article 8 sort of directs the investor that one of the most important decisions they make is choosing the intermediary with whom they want to deal.
Yeah. Vitae Van.
Stay with you for a moment, Chuck. We've heard a lot of references to Article 8. What legal structure for beneficial ownership should be applied to digital assets? Is it different than traditional assets? How does Article 8 potentially solve that? Should the Article 8 be mandated by the SEC to be what's used
Hit that light button.
by custodians if they're going to be qualified custodians for these kinds of assets?
Well, I would reiterate the latter point. My answer would be yes, because the alternative is common law and contract and maybe analogies to bailment. And at least with Article 8, you know that the assets, the entitlement holder has a property interest and that they're not subject to the claims of the intermediaries' creditors. But it doesn't solve the solvency risk. And when we were drafting those provisions, the unanimous view ended up being that anything that in the account agreement between the customer and the intermediary, they agree can be a financial asset, can be, and that can be the Mona Lisa or a ham sandwich, as unwise as that might be for an intermediary to undertake the custody. But that leaves the lack of regulation where Article 8 would still apply, and so this is something that we need to think about.
Zach,
Get 'em,
just
Chuck.
building on that a little, on the earlier panel on broker-dealers, you kind of mentioned the fact that oftentimes the commission's sort of analysis on good control location, goes to, this is a bank, and sort of stops there. And that's fair to some extent, because banks are heavily regulated. There's pretty clear structure in place and all of that, and so it's legitimate for the commission to
Yep.
sort of draw the line there. But on these assets, I mean, I think
High demand.
legal structure becomes more murky, because I don't think you can just sort of draw the line at bank and broker-dealer in every instance. SIPC protection, for example, SEPA protection, for example. I mean, many tokens, even if they are securities, unregistered investment contracts wouldn't come within SEPA's definition. So then
Right.
there's the question of, well, it's a broker-dealer, but does that really get you anything in terms of the specific tokens or specific assets that you're custodying? So I think, I would say legal structure in that sense is it shouldn't be either a necessary or a sufficient condition. It's a good to have, but I don't think you can sort of just draw the line there.
So changing topics a bit, while they weren't registered advisors or funds, firms like FTX and Celsius and Voyager failed, which has raised a lot of questions, and those that are advocating to separate functions, to separate out the exchange function from the custody function and the clearing function, on the basis that having those separations sort of makes things safer. It's easier to find, to spot when there's improper conduct going on. Is that
The haiku.
necessary? And if so, is self-custody even really an option, or does that just bring you back to the same kind of risk that you have in those firms? I don't know, Adam, if you want to start with that.
Sure. With your FTXs or Celsiuses or Voyagers, the part of the problem that arose in those cases was that they were engaged in a variety of different and really distinct activities. But you thought if you had your tokens on FTX, you thought they were sitting there safe, just like you would have
You guys
money
are
in a bank
killing me.
account or something. And or really in a safe deposit box at a bank rather than the account. And the problem was that FTX was deploying them, and deploying them not so wisely as it turned out. And if you want to make sure that that your tokens are really going to be safe, you want them in the equivalent of that safe deposit box, which is it actually is a multi-key signature solution, or bank vault, where it's not exposed to, you want to keep them unexposed to other activities. And there's operational
back.
risk that goes on with an exchange. The exchange is trading for its own account. It can just run. There's a range of problems it can run into. You don't want any of that to gum up the safety of your own holdings. And there are a lot of good trading reasons why, if keeping everything in an omnibus wallet on exchange makes it a lot easier and cheaper to trade. We're going to trade off chain, so we don't pay gas, and we're going to be able to do everything. Everything can settle pretty much immediately because it's just an Excel spreadsheet for their books and records or whatever. But it does come at the expense of safety. And if the goal here is to prioritize safety of customer assets, you really want to try and eliminate the risk of the credit risk that comes from the custodian's other business. So one thing might be just saying, hey, custodians, you can do one line of business and one line of business only. This is kind of the extreme. You're just basically a box for holding somebody else's crypto. That's probably the safest. There may be reasons why we wouldn't want to do that. But you might also think about other activity restrictions where maybe you don't want the custodian involved in trading in crypto for its own account. Or maybe you want the custodian to be at least in a separate legal entity from affiliates that engage in other crypto activities. That gives you, that gets you maybe somewhere down the road to having a bankruptcy remote entity. That's at least a first step. And maybe you want to even think about having something like, taking from the banking context, something like the source of strength doctrine, where all in a bank holding company, all of the non-bank affiliates are supposed to be a source of strength to support the depository, rather so that the depository obligations effectively come ahead of everything. I think, I think we want to at least start to have a conversation about the regulation in terms of business activities and organization of custodians, whether it's an internal, the investment advisor self-custodies, but through through a subsidiary, or as a standalone third-party custodian.
Just looking around if anybody else had thoughts on that. Okay, I guess a unique feature, moving on a bit, of crypto is staking. We've talked about this a bit earlier, it came up, but I wanted to sort of drill down on it a bit more. And people argue that on the one hand, a advisor has a fiduciary duty to make sure that it engages in activities to benefit its clients, which would include engaging in staking to earn the yield. On the other hand, if they've got to hold it at a qualified custodian, that raises challenges because they may need to send it to somebody to engage in validation, they may need to delegate it. It doesn't sit sort of still in the same way. How do people think we can square that circle and have the best of both of those worlds? Is that possible? Justin, can I start with you?
Yeah, it goes back to the conflict that we were discussing earlier. And in some ways, staking is the best illustration of this conflict, because at a very theoretical level, I think some might argue that there's absolutely no way to stake assets through a custodial framework, because when you stake assets, you're moving assets on chain into the staking contract, and no custodian is actually holding them in theory, right? And so I don't think there's any custodial solution that would meet the competing goals of the custody rule and the Advisors Act fiduciary principles. And as I said before, when you look at the competition between those two goals, the Advisors Act fiduciary duty of care should win out. If you go back and look at the 2019 fiduciary interpretation that essentially distills down 80 plus years of precedent based on centuries of precedent from the law of trust and agency, you actually can't find any discussion about safeguarding or custody in that release. And I think the reason is that the safeguarding rule flows from the overarching duty of care, which is to invest your client's assets according to their mandate and according to their best interests. And so if you apply that doctrine to staking, the reality is that assuming the primacy of the duty of care, advisors ought to be able to stake their clients' assets outside of a qualified custodial framework. And frankly, the technology doesn't, as I said before, the technology really doesn't support any other way. So there has to be a balancing. And for clients that say to their advisors, please stake my assets, it's hard to decline to do so without running afoul of Section 206 of the Advisors Act, which is the cornerstone of the statute.
I'm back.
Well, perhaps a way to rationalize this, which is sort of a glaring apparent conflict in these,
Oh, here's
is
Chuck
to try
again.
to distinguish between the risks that are inherent in the asset and the asset's inherent attributes from those risks that we expect to be protected against by custody. If I tell my broker-dealer to sell 100 shares and they go in the system, think of staking. The custodian has lost complete control. I'm now expecting that tomorrow I'll get cash in return. And that's really the only way I can get the asset value
Oh, I'm entertained. I'm having a blast.
back. Well, if I have staking,
Especially after that break I just took.
it moves into that contract ipso facto, and immediately the investor receives all the benefits and attributes that flow from that. And it seems to me that if there's some risk there, that's just something that goes along with what the asset is, and those are more akin, I think, to, the broker-dealer doesn't guarantee solvency or that the bonds are going to be paid. And so, what's custody responsibility and what's just and hacking is an example, just an inherent aspect of the assets. They're on the internet.
But he needs to differentiate between native non-counterparty and issued assets.
Sure, all.
Custody.
Think about that.
Custody.
Yeah, and it seems like what we might be talking about here is essentially, some types of non-exclusive safe harbors from the prescriptive rules of custody to allow for these, potentially common use cases.
Smoking a pancake.
Where the client is,
A
either
blitz and a
directing
blow.
it or, it's clearly disclosed and the client, wants to participate or is given the advisor discretionary authority to allow that. And it's, fully disclosed, the risks, et cetera. But I think, we could think about maybe some non-exclusive
Yes,
safe
sir.
harbors to allow that outside of the confines of the custody rule.
So I would analogize this to staking to holding customer cash.
Jeffrey, this is a meeting of how we can take away self-custody without making them too mad, and how we can keep third parties in business. Third-party custodians, how can we keep them in business?
Cash.
How can we get fees?
Right, and certainly if you're holding customer cash, it's not a ridiculous thing to
Yeah, I hope they
put
stream
it
from
in
Austin.
a bank account that's
Somebody's
not the
going to.
custodian. It's a contract with the bank. When you put money in the bank, it's not your particular dollar bill. It's you just have a contractual claim with the bank. It wouldn't be ridiculous for
Maybe I can start a stream and somebody will call in and I can stream it. I don't know.
for a custodian to put customer cash in an interest-bearing account. So this seems analogous to this, but by the same token, no pun intended, a custodian shouldn't just be putting customer cash into any bank, right? It shouldn't be putting cash into an uninsured bank. It shouldn't be putting cash under its mattress. It should be taking some level of care about what the bank is. And I think that points to a custodian needing to undertake some level of diligence about the staking. And I don't know what that would be, because it seems unrealistic to ask a custodian to go and evaluate the code for a staking contract. That's just beyond the skills of, I think, pretty much what any custodian has.
You're right.
And yet, there is some risk there, right? If you haven't examined the code, you don't know exactly what lurks there. And if you don't know if the code relies on an oracle, what's the oracle risk? Is the oracle really reliable? I don't know where we would say what the appropriate type of diligence would be, but I think there needs to be some level of care in staking, even if you think that staking is consistent with custodial duties.
Neil.
So just one note. I'll
No, I can't go, man. Hope you guys have a great time, though. Yeah, I'm sad I can't go, but hopefully next time.
I'll add there is, I've basically had this view that Justin started with, that it's very difficult to reconcile sort of having the asset remain in custody, with a qualified custodian or otherwise, and exercise the range of rights associated with the asset if that requires taking it out of custody.
Yeah, where'd he go?
Irreconcilable. But one of the things about crypto is that anything I say could be obsolete by Tuesday, and I think this is one of those, because like point and click staking, I think is an example where it seems like technologies are emerging where, crazy as it may sound, you may be able to stake without, at least theoretically, taking it out of custody. So
Well, duh.
that's a different question to be explored, and that is a technological question as well as a
That's liquid
more
staking.
technological question than a legal question. But maybe what I would draw from that, and building on Adam's idea of diligence, is there's got to be some understanding of what is truly necessary in order to stake. And I think, Zach, in discussions, you've alluded to 17F2 and the Companies Act as a potential sort of framework. And I think that might be the clue here, which is, is it necessary to take it out of custody to
Wow.
stake it? If it is, what's the period? And
They're
then
talking about
other practices.
liquid staking, locking it up safe in a custodian, but still being able to stake it, us being able to use it and stake it somewhere else. Wow.
Practices that sort of go towards sort of mitigating the risk around that. So that's, and there, I think, it's really an interesting question because it opens up many other doors. And one which it opens up is the SEC went after staking as a service for a very long time, but it does afford significant, protections to customers that sort of independent staking doesn't. For example, you can cash out, you don't have to wait for the bonding period, you're sort of protected against slashing and various other things. Is there a case for sort of saying that advisors should prefer staking as a service over independent staking where it's available? I don't know, but I'm just saying that I think is the kind of calculus that this introduces into
The staking service providers or the liquid token
They're
staking
trying to put a dog leash on a dragon is what's going on.
providers would love to hear that your views. There's a fiduciary duty for advisors to use their product instead of others.
They can't
not say
quite
that.
figure out how to get it over his head.
Just to add on there a little bit, like
Oh,
I think this
Larry's
comes down to
talking.
manager
He hasn't talked the whole time, has he?
discretion a little bit too. If a manager wants to use a
Yeah.
staking service to stake their tokens, they should be allowed to. If they want to keep it at a custodian because they'll stake it on your behalf, they should be able to. If a manager wants to run their own validators and do it themselves, they should be allowed to. I think that a lot of what we're talking about today comes down to trust. It's trusting intermediaries, it's trusting counterparties, it's trusting that when a custodian says that they have your assets, that they actually have your assets, even though it's all
Trust
sitting
me, bro.
in this black box. And I want to bring it back to an earlier point that I made, which is that crypto is a fundamentally different system architecture where you don't need to have trust as a component
Right.
in your analysis. You can run
trustless.
this on autonomous systems based on open source code and not trust. You can simply just verify. You can look at the code, you can see how it works, you can see it on chain,
That's
and
blowing their minds right there. Not have to trust something.
you know where it is. So again, if a manager doesn't want to do that, if they don't want to take that on themselves, that's fine. But if they want to clip those extra points because they're doing it themselves and they think that they can manage the OPSEC to keep their wallet safe, they should be allowed to do that too.
I would just say I come back to, pillars of the Advisors Act are fiduciary responsibility of the advisor and disclosure to the investors. And if you take those two together, you're going to come out with, is it appropriate? Would an advisor consider it appropriate to stake for a particular investor under particular circumstances, given the system involved? And so I think it's very difficult to mandate kind of one system or over another, or whether you can stake or not. I think it comes down to, to a certain level, the advisor has a fiduciary responsibility and also has to disclose what they're doing to their investors.
So coming back to something was touched on earlier, including Commissioner Ueda mentioned it. In the SEC's proposed safeguarding rule, there was something of a bomb thrown in there, which took the view that crypto assets are likely either funds or securities, and therefore subject to the rule. There's a point that Commissioner Peirce specifically called out as inappropriate to put in a proposing release, but there it was. Under that, it would mean that the rule applies right now. Do people think that is the correct interpretation of the law? And should the SEC, if not, withdraw it? And what should advisors be doing today if they are supposed to be subject to this? And for assets like the one you mentioned, Justin, there is no qualified custodian for. How do people manage that situation? I don't know, Ryan, if I could start with you.
Yeah.
Is she a wizardess or a sorceress?
I mean, no, I don't think that's grounded in good law that all digital assets should be treated as funds or securities. I think there are certainly many that are outside the scope of that. But I think goes back to, and it's a point that Susan just made, is that even if the asset
Probably.
doesn't fall under the prescriptive confines of custodial rule, that doesn't mean that the advisor isn't still subject to a fiduciary duty to safeguard that asset. And so, I think it goes to, the advisor's fiduciary duty that it still needs to safeguard the asset. The challenge, though, is the way the rule's written right now, and that safeguarding of the asset, if it's treated without sort of that specter of that interpretation still hanging
guys
out
are
there, I
true.
think a lot of advisors are saying, boy, if it's treated as a fund or a security, we better look toward a qualified custodian. They may actually prefer that or believe that another entity that isn't technically a qualified custodian actually can do a better job, yet they're subject to potentially that interpretation. So I do think that one could be clarified, certainly, to allow to clarify that, certainly not all digital assets are funds if they're not otherwise securities.
Or memorabilia or collectibles, like meme
Something else we
coins.
talked a bit about earlier is the fact that crypto trading platforms themselves tend not to be qualified custodians. At the same time, unlike the traditional securities markets where, you might trade and then it doesn't settle till T+1, gives you time to tell your custodian to move it, crypto platforms tend to settle or expect settlement to be immediate, real time, so they want pre-funded. If you want to sell your Bitcoin, you need to put your Bitcoin on that platform. Similar issue in terms of fiduciary duty balance is that that's where the liquidity is on those platforms. So there may be, I've heard an argument, there's a best execution obligation to use those platforms even though they are not qualified custodians. Should there be an exception? Neil,
It's all about liquidity.
mentioned something earlier, but an exception that would allow crypto to be held on non-qualified custodians, neither self-custody nor to qualified custodian, because it's going to be held on this crypto platform in anticipation of trading on that platform. Neil, did you want to elaborate on that? And what those conditions should be, if any?
No, it's a hard question. I don't actually have
Conditions
a
of
really
trading?
good answer to this because look, I think the degree of friction that sort of introduced is just very, very significant for exchanges. If you sort of split it up in any very material kind of way, and then that really calls into question sort of operations. So I feel like there's got to be some answer here that basically requires the exchange to adhere to sort of custodial requirements in the same way that we might ask third-party custodians or self-custodying firms to do, because I think the alternative is simply unworkable for them. So that's, I think, where I probably come down on this question. And for firms that are, by which I mean RIAs, that are sort of using these exchanges, and I think centralized exchanges is a harder case than decentralized exchanges to some extent. But for firms that are using these exchanges, it's notable that the safeguarding rule actually took the view that you couldn't do it. Like you just couldn't put your stuff on a centralized exchange at all. So that's sort of the view that Justin alluded to earlier, which is, custody and care over everything else, or custody and security over everything else. But I'm not sure that that's necessarily the best way to look at the three elements that typically make up the advisor's fiduciary duties, because best execution is one of them. You can't just sort of look past it altogether. So my preferred alternative would be sort of imposing custodial limitations and custodial requirements on the exchanges at some level. And frankly, I think the better exchanges do it already. So that to me is the answer, rather than sort of saying you can't do it or that you need to split it up.
So
that
essentially
it increases
expanding
friction.
who can be a qualified custodian
Exactly.
for this asset class to include under certain conditions.
Well, that or yes, and in the sense that either that or saying that self-custody by exchanges is permitted in some respect. So it'll be somewhere between those two.
Mike, do you have any thoughts on this one?
I don't.
Okay. Susan,
I want to touch that one.
One thing we talked about is that there is a exception for investment companies that allow them to self-custody or an exception from holding their assets with a bank or broker for things like securities in transit or other transactions where necessary
Yeah, I'm gonna put you guys in a timeout. Kids getting rowdy in the back seat.
or appropriate. Is that sort of a good model, that this is an example where it's just necessary or appropriate? There's no other way to do it? There's no way to hold it at a bank because that's just not the way the market works?
Yeah, I think we have to think about the system that we have now, and if you're going to impose regulation, are you going to work with that system, or are you going to impose requirements that are going to cause the entire system to change? Because with the Investment Company Act self-custody rule, there was this notion that while certificated security was in transit, so in other words, it left the bank vault and now a bike messenger has it and is bringing it over to another owner, that while it was in transit, it didn't have to be held by the qualified custodian, because at the time you had bike messengers doing this transit service. So you
there's
could have
no
written
need.
the rule, though, to say the employees of the custodian have to employ the bike messenger, and they have to do X, Y, and Z to bring it over to the new owner. But that wasn't the decision that was made. The decision was,
Oh, okay.
we have a system in place, and so we're going to just say that there isn't a big problem with bike messengers stealing the certificates, and so we're not.
Claire and
gonna
HBAR
require a
already have
qualified
liquids
custodian
taken. Cool.
during that bike trip. And
I know
think
that
it's the same type of
XPRT
question
was one
where
of the
it's,
first ones
you have a system right now.
that did it.
It works a certain way that doesn't line up with what we think of in terms of traditional custody. And so do you want to work within that system and impose requirements that make sense for that system, or do you want to have to upheave that system and create something new?
Create something new. Let's move on.
On the
Burn
question
the
of qualified
old.
custodians, something Commissioner Uyeda said earlier about the SEC or staff considering the role of certain state-regulated entities, I thought people might be surprised to hear, because I know there's a lot of firms out there that sort of take the view that those state entities are QCs. Are there ambiguities in terms of whether those kinds of trust companies or state specialized bank charters actually are QCs, and should the SEC be more clear and clarify, what is a qualified custodian, even within the sort of vague bank definition? Ryan, can I start with you on that one?
Yeah, I mean, we have a New York limited purpose trust company, and I think about, how we're required to act and breathe every day. I mean, it's really under New York banking law. I mean, it's chartered, it's overseen, it's governed by the banking regulator there.
I agree,
and so
Don.
I think the point
Yep.
maybe Commissioner Uyeda was trying to tease out was, but, maybe not all states sort of act or treat that way to different limited purpose trust companies. So I do certainly think that, under the definition of bank could be a limited purpose trust company, and should be. But it's not clear to me that necessarily every state, has the regime, has the, experience, the expertise, the oversight to treat the trust company as if it's operating like a bank. So I do think that it should be clear that, those types of entities and those types of states that really act
Quiet
and
over there,
treat their
Chuck.
trust companies under the banking regime.
Keep it down
should
on the end.
clearly be qualified custodians, but I think there would need to be a framework to be clear that the state needs to do X, Y, and Z, and the trust company chartered within those states to qualify.
So the SEC would sort of dictate what states would need to require.
I think so. Yeah. I mean, I think I do think that at least indicating that to the extent the trust company is overseen under the state's banking law, chartered, supervised, and then also within that language is that there's a fiduciary context. So the trust company is also authorized to, or the custodial activity is a fiduciary activity, and that. Ergo, if the trust company is providing custodial activity, it's doing so as a fiduciary. I think under those circumstances, yes, that it should be a qualified custodian. I think that should be made clear.
Yeah, I would characterize the issue as more complexity than ambiguity. The definition of bank is needlessly complex for these purposes. It has a good purpose for other purposes under the statute, both statutes. The definition of qualified custodian, which by the way was only introduced 20 plus years ago in 2003. It's pretty new. It incorporates a definition of bank. The definition of bank points back to OCC interpretations for purposes of evaluating whether a non-depository state trust company could be a qualified custodian. So what folks have had to do is go back and parse through all the OCC interpretations on what constitutes a fiduciary activity. And those interpretations have changed over the years.
Me too, man.
And they change from administration to administration. So it leaves the industry in a little bit of a pickle. I think the industry's done a really good job of navigating the definition so far. I think there's no one out here that doubts that a New York State Chartered Trust Company is a qualified custodian. But to encourage competition, to bring more qualified custodians into this space, which frankly I think the industry needs, you could pretty easily solve that complexity by defining a bank for purposes of the qualified custodian, or just defining a qualified custodian as including a state chartered trust company that does X, Y, and Z. There's a framework in another part of the statute that the NISMIA implementing provisions that talk about the divide between the states and the SEC around advisor regulation and registration, and it turns on whether a state, in part, turns on whether a state supervises and examines a particular advisor or has a regulatory regime for advisors within that state. That might be something that you could graft onto the definition of qualified custodian to clear this up.
Susan?
I agree with everything that Justin just said. Yeah, I was going to bring up that mid-size advisor provision as well, where it talks about, it's not just enough that it's left to a state. The state has to have certain regulatory things in place. And I guess that brings me back to, what is a qualified custodian and the principles that you would look to, and, is it a regulated entity? And if it's regulated, does it require policies and procedures? And does it require a third-party audit and things like that you would want? Because there might be other entities as well besides state-chartered trust companies, like perhaps licensed money transmitters also you would look to. They have capital requirements. They require AML controls. So I don't think I think if you're just acting within what the rule says right now and you have to fit within that bank definition, then the state-chartered trust company question comes into play. But if you're thinking more broadly, I don't know that you would necessarily want to limit it to just things that could fit within that bank definition.
So when I asked a question earlier about the SEC dictating what the states do, I was a bit tongue-in-cheek, because I think the SEC generally doesn't want to be dictating what bank regulators do, certainly at the state level. But it sounds like there may be some precedent where the SEC sort of sets a threshold, which, like, if the entity is regulated in a particular way, that could be grafted on. And then, Susan, just to sort of continue on the last thing you were saying, and this builds off of what Neil was saying as well, in terms of who else could or should be a qualified custodian? Does it have to be, a bank, a broker-dealer, potentially a trust company? Should it be expanded to MTL holders or specialized state licensees like New York's BIT license? I think California and Louisiana and other states are developing similar regimes.
They have a
Would it make
mask on.
sense, particularly for crypto, for there to be licensees that qualify based on those other kinds of activities and licenses beyond being a bank? And if so, what should those be? Chuck, can I ask you?
Well, one place to start might be to look at entities that the SEC already places great trust in. The Depository Trust Company, for example. And to
Bring it, Chuck. Come on now.
Question, if that's sufficient there, why shouldn't it be, a New York Trust Company sufficient somewhere else? But I generally agree with what's been said, that some standards need to be imposed here. And the problem is, if I may just raise a general challenge, which I'm sure the SEC wants to hear even more challenges. When a lot of rules are made, whether it's private law or regulatory, we've got an infrastructure out there, and we're trying to fit the rules for the infrastructure and what it does. And here we have no infrastructure except one that's constantly evolving, and that's really a challenge. And I'm sure they will do a good job.
Please, Adam.
I would just say I'd be really uncomfortable if money transmitter licenses were sufficient to qualify someone to be a custodian. The licensing process for money transmitters varies significantly from state to state, but in many states, it's not a very high threshold of what you need to get a license. You know, you have a few $1 million, you can get in business with it, assuming you don't have a criminal record.
Neil? Or Ryan?
Oh, I was just going to say, yeah, I'd add on to that too, but I think it's also, going back to those core functional requirements. So, and that goes to sort of segregation of assets from proprietary assets, auditability, security protocols, legal enforceability against insolvency, sort of the points you were making. So I think there could be established criteria. Maybe an entity has to be, a certain licensed entity, but nonetheless, I think that there could be established frameworks so long as it's meeting these, certain criteria and functions, especially when this technology is fast moving, and recognizing that the advisor, has this overarching fiduciary.
Yeah, I love loan protocol too, man.
Solution there.
So easy.
One area where I just think there's going to need to be a lot
same
more
here.
sort of
2029, I
is
think.
around what you mentioned earlier, Zach, technology provision. So where does somebody stop being a technology provider and become a qualified custodian? That line, I think, is going to be increasingly blurred.
It's a hard question in this context.
Yeah, very hard question in this context, particularly because many technology providers do not want to be qualified custodians, or you just provided the software, and that's basically all we're doing. But at some point, you realize that there is a gap in the sense that people are looking to those technology providers as basically being their custodial solution. So that that gap should not translate
I'm not sure,
to
Jeff.
a mismatch with the end customer or the end user's expectations.
I can look it
What's
up.
going on with his or her assets. So that's one point that I will make there. The second point that I want to make here is we've always had this, and this is a particular interest of mine, but the foreign qualified custodian. I've never quite found out who those guys are, or like, what the details are on that. I mean, I think the safeguarding proposal goes into a lot of detail about what we would expect around them. But as the law stands, I don't think there's a lot of discussion. But in the crypto world, assets are traded globally. Firms don't necessarily exist anywhere in the traditional sense. And so what really would that fourth prong of the qualified custodian sort of cover, or the third or fourth prong qualified custodian cover? I'm not quite sure.
So I think, sorry, Ryan.
Yeah, I was just going to say where I think it becomes really interesting is,
Ripple holds money transmitter licenses, MTLs, in over 50 U.S. states and jurisdictions. So that might not mean every state. It might mean so many states plus so many jurisdictions within those states. This figure is based on announcements made Ripple January 2025. They have over 50 MTLs, but it's weird the way it says it. 50 U.S. states and jurisdictions. No, that's all states, plus the jurisdictions within those states. Yeah, that should be everything.
What we're
they're
moving
covered.
toward are programmable assets, via smart contract infrastructure, and do those assets take on some custodial qualities? You can freeze the asset, you can claw back the asset, and have that function that if X happens, then that action will happen, which in some ways, custodians are charged with doing that. So over time, as we're sitting here, 10 years from now, do we see a framework where, in fact, the asset itself is taken on some custodial function? That's where we're very excited about sort of seeing that.
No, we'll
that
let Buster
evolution,
run the
hopefully,
diesel for you
come to
guys.
fruition.
Uh-oh.
Please visit the Crypto Task Force website where you can provide written input,
well, I guess I could run it
request
now.
a
I got
meeting with the
time.
task force, and read the many great submissions we've already received. We
I don't
want
know
to
how to play it,
continue the great work that the task force has been doing with everyone's help. So we have 2 more roundtables
I
to
can play
go
the
in our
audio.
sprint. Up next, we will focus on.
Crank up that diesel.
There you go.
Let's go diesel.
There you go.
And tokenization.
I think that's the end of the.
That's going to be here in just over 2 weeks. We'll be on a Monday, so we can all stop making the Friday
I think that's the end of the
references. I do
second
appreciate
round.
everyone who has been here for the 3 Friday roundtables so far. Apparently, there are a host of you that have attended all 3, have a perfect attendance record so far.
Missed a
So
little
if you can
bit
make
because
to
I
the other
paused
2,
it
I'm
just a
gonna
few
come up
seconds. So
with some sort of token.
fees, and
for-
more fees. That's right. That's what it's all
your
about for them, to
participation
keep that
that will
control,
comply with all government ethics rules.
to keep that business model
Thank
going
you
of
all
free
so much.
money.
Have a great weekend.
Free money. They want to keep it going. But we're changing the system, guys. We are changing it up. They're trying to make the legacy system work with this new stuff that we're into. Truth and transparency. Appreciate everyone in the chat. I had a great time with you guys today. As Miami Dolphins fan, I find that offensive. Oh, the diesel, yeah. Got a big race in Miami next weekend, F1 race. I'd love to try to get down there and check that out. Street race around the stadium down there in Miami next weekend. That'd be good. Well, I hope you guys got a little something out of this. I did. Basically, we know what's going on. We know their game. We know what they want. They're still fighting over territory. They still don't want us playing with their Pokemon cards. They're still learning what we already know exactly. TNT Dynamite. All right, guys. Enjoyed everyone tuning in. I hate I can't make it to the moon party. Hope you guys have a blast. Some of you guys are probably already there or on the way there, yeah? You got an eye full of eye candy with sweet Hester. Jeffrey, everybody's fighting over Hester Purse. Settle down, guys. Settle down. Take a cold shower. See you guys on the next one. MrConectr out. Later, guys. One love, moon party.
That diesel. Let's go diesel. Crank up that.
Crank up that diesel.
Diesel. Let's go diesel. Crank up that diesel.
I need to sample that. I guess I kind of am right now. All right, I need to end this stream sometime. Laces out, Dan. Yeah, laces out, Dan. You had one job. Hell yeah. Enjoy you, Bradley. Hang around, man. I get you a wrench. I like to keep, some non-wrench. That way it's more inviting for other people. So help me with that for a while. Peace out, guys. Oh, yeah. Happy Friday. It's the weekend, baby. Let's go. Crank up the diesel.